In this video, we're going to cover classes 6 to 9 of the Comparative Commercial Arbitration module at the University of Westminster. And that's going to take us into the complex world of procedure. Let's begin with the core basic rule. We'll begin on the current slide. It's the easiest way to do it. There's a core rule. Parties agreement subject to public policy dominates everything. But that parties agreement may be agreement to an institutional rule or ad hoc rules like the UNSTRA rules. That is part of the parties agreement. Parties can't agree, the arbitrator makes the decision. You could end up going down a documents only route, but be careful because Dutch law and the ICC rules require some sort of agreement. However, if you do hold a hearing, you can't hear everything. You can't allow the parties to take years churning out witness after witness after witness. There has to be some sort of control. The first job, though, is to commence arbitration. And that depends, according to most national laws, on the parties' agreement. And that leads you to the rules of any institution, or indeed ad hoc rules the parties may have selected. If you don't have such a choice, you are then forced back onto national law. This is incredibly important, by the way, because if there is some form of limitation on the time you have to commence arbitration, or ordinary time bar rules apply to your case, it may be vital to know exactly when you commenced arbitration and thereby stop the relevant time limit running. This is the pretty classic answer. I want the other side to arbitrate this dispute. Just that simple request will kick off the arbitration. The English Act is a little bit more nuanced, inviting the other side or any appointing body that has been agreed to appoint an arbitrator. The Dutch, slightly different rule, but not that different. You send a notice that you've begun the arbitration and set up the dispute in question. All these things will be deemed to have commenced the arbitration. In ICC cases, in common with a number of other institutions, you do this by sending a request for arbitration to the Secretariat. Its receipt commences the case, and your request has to contain certain information. Much of it's pretty obvious. It's important to get the estimated monetary value right because it affects the size of the deposit that the ICC will insist on. Any agreements, if you've got claims under different arbitration agreements, they should all be supplied properly and clearly. Other than that, suggestions as to arbitrators, how many there should be, who might be appointed, seat of arbitration, applicable law and language, all have to be there. And you can throw in anything else that you think might help, but please don't try to argue your case in your request for arbitration. There is an answer and counterclaim which follows exactly the same route, and there's no need to set out the same information. The ICC Secretariat can give you a bit more time to file this over and above what it says in the rule book. Generally speaking, the ICC will go along on the party's suggestion of arbitrators, but ultimately it's the Court of Arbitration that appoints the tribunal and can reject an arbitrator, even if both parties are agreed on that person. An issue that came up in another institution was the situation where the parties had agreed on an arbitrator who insisted on being paid above the going rate for that institution's arbitration. The benefit to the institution of having an agreed to sole arbitrator charging a higher rate, however, could have overridden their concerns about the fees, because it's a lot cheaper to go with one arbitrator that everyone agrees to, typically, than three. even if all three are charging a slightly lower rate. There can obviously be a reply to the counterclaim. In ad hoc cases, things can be a bit messy. There is usually, though, a national legal system requirements for appointing. Courts can pick up the slack if the parties can't follow the relevant legislation. There is no worry about the Brussels regulation here. It's just worth pointing out, courtesy of the Mark Rich case. Generally speaking, the parties appoint their arbitrators by written agreement. It could be, though, the fellow arbitrators that have to negotiate the appointment of a chairman. Typically, though, they nominate the chairman and the parties agree to that agreed nomination. Institutions frequently appoint arbitrators. They have their own charge-out rates, which makes things a little simpler, or the court ultimately could find themselves doing this. There are a couple of quirks worth noticing in the English 1996 Arbitration Act. Courts can extend time for commencing arbitration, as they can actually for issuing an award. There's party agreement on those subjects. And they can do so even after the time has expired. That's typically when the application is made. Obviously, if you're applying to a point out of time, you'll be expected to pay the cost of the application. Where a party appoints an arbitrator, invites the respondent to do the same, and the respondent doesn't react within the time limit provided, then the claimant can nominate their own appointee as the sole arbitrator, inviting the respondent to apply to court if they're not happy with that arrangement. This is a way of stopping the respondent from blocking an arbitration where the arbitration agreement provides for more than one arbitrator. And it is a sensible way of doing things, but it does create the occasional enforcement dispute because it can be argued the procedure was not in accordance with the agreement of the parties. Article 51D of the New York Convention provides that as a possible defense. However, the Italian courts, and virtually anybody else who's ever had a look at this one, conclude that the parties agreed to an English arbitration when they choose England as the seat, and thereby subject themselves to this slightly eccentric, if highly effective, rule. The IBA guidelines on the conflicts of interest are used as a touchstone, I suppose, of this subject. When you get invited to be appointed as an arbitrator, you get typically asked to make any necessary disclosures. The test is basically if there are any justifiable doubts about your independence, you can be removed as an arbitrator. But there are a number of features of the IBA guidelines. They do look at how closely you or close family members are identified with one of the parties, and similarly whether those people have a significant financial interest in the outcome of the result. When in doubt, disclose is the oldest rule in the book, and under the IBA guidelines, you are your law firm. That creates problems for arbitrators who work for big law firms, who typically keep conflicts lists, and many arbitrators in recent years have left big international firms in order to avoid being effectively conflicted out of arbitrator appointments. The color system, often seen as traffic lights, isn't quite right because there's red non-waivable and red waivable. If you disclose your red issue, the other side can, or the side that is less closely affiliated with you, can say that's just fine, don't worry about it. Orange, you only have to disclose. That opens up the possibility, of course, that a party will apply to remove you as an arbitrator. Frankly, if you don't disclose, as the Supreme Court pointed out in the Halliburton case, you increase the chances that there is justifiable doubts about your independence. So if you know something, disclose it It's a pretty common rule, or decline the appointment. It's a green list one, and we won't deal with the green list ones. You don't have to disclose. Word of warning, however, just because you've got a red non-waivable doesn't mean that the award should be set aside or the arbitrator removed. In the W case, the arbitrator, a Canadian lawyer in the litigation department of a large firm, had no idea about the merger, which had the effect of making his law firm the advisor to an affiliate of one of the parties, which is a non-waivable red. The court said there was not a reason to remove the arbitrator as arbitrator, and it wasn't a ground to set aside the award either. In the non-waivable red category, and yes, the street sign really does exist in Sydney, New South Wales. Legal representative of party, controlling influence over a company, director, manager, significant financial interest in the outcome. You'd expect all these to be non-waivable reds. This is the one that caught out the lawyer in the W case, and it may in fact not produce justifiable doubts about neutrality because the arbitrator may not know about it. In that case, the arbitrator also protected himself by making a number of other disclosures about his relationship with the parties, which didn't lead to any application to remove him. In the waivable red category, for which express party agreement can be used to override a red issue, if you advise the lawyer or an expert on the dispute, a party or an affiliate, previously in the case. Privately owned companies are rather different from publicly owned ones. If you own shares in a privately owned one, you are usually quite closely connected to them. Close family member having a significant financial interest in the result. Close family members are a real problem in this area because you don't typically know the position of people that are quite closely related to you. Similarly, you could have, or your close family member could have a close relationship with a third party who might have insured an outcome or promised to indemnify an unsuccessful party or guarantee a relationship in some other way. That could give you a problem. On the personal side, yeah, represents currently or regularly advises, represents counsel, that's a problem, or their firm. You wouldn't necessarily know that, and counsel changes. You may find yourself in the embarrassing position of pointing out that now you have a waivable red. You just disclose it in real life. And if the other side wants you to be removed as an arbitrator, pay your fees and let you go on your way. If you're in the same law firm as counsel, then you shouldn't be an arbitrator. But there is this strange exemption for barristers, of which more later. Manager, director, significant influence of an affiliate involved in the matter in dispute. You regularly advise the party or affiliate. Close family relationship to a party, manager, controller, party affiliate or counsel, or a significant financial interest in one of them, in a close family member. Law firm previously involved in the case, that you do need to know as an arbitrator, probably do know it anyway, or has a significant commercial relationship with the party or affiliate, even though they're not currently giving advice to that party. On the orange list, now you only have to disclose you've been counsel for or against one of the parties or consulted. A lot of these relationship ones can sometimes be exempted as a result of a footnote in the IBA guidelines to cover shipping cases, commodities, and the odd insurance dispute in particular areas where there is a limited pool. There's a disagreement in the Supreme Court in Halliburton as to whether this exemption should really apply. I'm very uncomfortable about it. Either way, in Halliburton, the arbitrator in that case was appointed twice by one of the parties subsequently in a connected matter. Those should have been disclosed in the first arbitration and weren't. And the Supreme Court was pretty unanimous about that, although it didn't find any reason to remove the arbitrator, partly because when challenged on the matter, the arbitrator was quite open and did promise to resign in the event of the two subsequent cases coming out in a particularly different way. I'm not sure that was terribly acceptable. And the effect of the Supreme Court's decision is that you don't accept subsequent appointments from the same party without disclosing them in some form or another. There is a confidentiality issue, but if that happens, then you just don't accept the subsequent appointments if one of the parties involved refuses to let you make the necessary disclosure. Cofferley involved an individual who was appointed on multiple occasions as a result of a firm that helped people bring claims, suggesting to the Chartered Institute of Arbitrators they appoint an arbitrator with some very odd-looking qualifications, which tended to lead them to the same person, Tony Bingham. He was removed as an arbitrator, though, largely as a result of getting involved in the discussions about whether he really had to disclose how much revenue he was earning through appointments triggered essentially by the same claims management firm. If you acted for a party or an affiliate in the last 3 years, or you're an arbitrator on a related issue involving a party or an affiliate, or in the last 3 years you judged a significant case involving a party, or you've got a profit share arrangement with a firm that's currently servicing one of the parties. Do be careful here. Having close personal relationships is not being a pal of someone. In the legal world, we all have friends. That doesn't give you a close personal relationship. These are the obvious connectors. Careful though, because you won't necessarily know who the witnesses are going to be, or an expert witness, or indeed counsel, which may change halfway through the case. Remember though, the disclosure obligation is all that you have. You point out your connection, then invite one of the parties to object to you and show that there are justifiable doubts about your independence. But do please note that regularly spending a lot of time with someone isn't a close personal relationship, particularly if it is connected to your work, or that you're a member of a mosque or a church or a synagogue or a golf club or a bridge club. That's quite different to a close personal relationship. If you hold a significant holding in a listed party or a listed affiliate of one of the parties, yep, that's got to be disclosed. Or you've publicly said things about the case. Most appointing authorities will not appoint their staff. There's usually a sort of period of purdah when they can't be appointed after they leave the appointing authority. But if you hold a position like chairman of a committee within an appointing authority, that wouldn't be a reason not to be appointed, but you'd have to disclose it. If you have a controlling influence over a director who's not involved in the case, but is a director of one of the parties, well, then you need to disclose it. If another arbitrator is in the same firm, that might be quite a good idea, actually. It would save time and resource. Share the resource, basically, but you do have to point this out to the parties. This is the advocate or barrister rule, really the barrister rule. In practice, if you're in the same chambers as someone, if they're doing very well, you pay less than chambers expenses. So you actually have an interest in them appearing to be impressive as an arbitrator, and that's a problem. It also looks dreadful. So you have to disclose it. Then, if you've, in the last 3 years, been affiliated with an arbitrator or counsel, or appointed 3 times by counsel, that's quite important to stop multiple appointments being made, or by law firms, then that has to be disclosed. If you're a judge involved of a case involving the parties, even though it's not between them and it's significant, you have to disclose that. And where in the arbitrator's firm, the lawyer is, there's a lawyer in your firm who is an arbitrator in a sister dispute, typically another dispute involving one of the parties or its affiliate, that has to be disclosed, or a close family member, is a partner or an employee of one of the parties' law firms. Jan Paulsen ran a campaign a few years ago against the horrors of party-appointed arbitrators, and largely against some of the rules we've just been discussing. Essentially, he was a very good friend of the late Martin Hunter, and Martin Hunter always pointed out that as a solicitor appointing arbitrators, which he did for much of his career, he wanted to appoint arbitrators who didn't have any financial bias, but did have as much predisposition in favor of his side as possible. Jan always pointed out that a client that was a real nuisance and paid their bills late and haggled about them, you'd probably be hostile to them rather than in their favor. What this actually does is to stop people who actually know the companies well and know their foibles often from ever being arbitrators in cases concerning them, which, if there's an imbalance of power between the parties, can be a seriously bad thing. I remember disclosing to an appointing authority when I was approached about accepting an appointment that I'd done work for one of the parties and frankly hoped to get more work. The claim was being made against them was one, though, that I understood not many people did, because you had to be an industry insider in the financial services industry to actually understand the problem. I think that the claimant would have stood a much better chance with me as an arbitrator than almost anybody alive, even though I knew perfectly well that once I made that disclosure, there was absolutely no chance I would ever be appointed the arbitrator in that case. The other point that Jan makes is that allowing parties to appoint their own arbitrators, leaving aside the rules on bias, tends to produce a small pool of potential appointees as parties try to have arbitrators with lots of experience of the relevant procedures who are going to influence the other arbitrators in favor of the appointeur's viewpoint. This produces tribunals with too many lawyers and not enough accountants and not enough engineers and quantity surveyors. If we have a look at the perfect tribunal in an engineering dispute, it might be lawyer, engineer, quantity surveyor. You'll never get that if the two parties are appointing two of the arbitrators. There is no right to appoint an arbitrator, except obviously if the arbitration agreement provides for it. And ICC research, well, that favors the use of sole arbitrators. You don't get particular extra value from multi-party arbitration tribunals. What you do sometimes get is the undesirable consequence that there's sort of hudging and mudging in the award to keep everybody happy, and a lack of clarity about the reasons in case to cope with the fact that one arbitrator might be a bit uncomfortable about some of the reasoning. Arbitrators can have their authority revoked or removed. The word removal is a bit of a pejorative term, and so revocation might be a bit more polite and appropriate, because you can be revoked without doing anything wrong. The parties don't want you to be the arbitrator anymore for the obvious reason they've settled the dispute. They don't need the award an award on agreed facts or anything of that sort, so they just ask you to resign. More commonly, you get the situation where the chairman of the tribunal is hearing the case with two wing arbitrators, and the hearing hasn't quite got to a conclusion. The parties, knowing the problems of rescheduling the leftovers part of the hearing, agree that the two wing arbitrators shall resign, and the case will be concluded by the sole arbitrator who's heard the whole thing anyway. In that situation, you pay the arbitrators whose authority you are revoking, and the sole arbitrator continues. In the event of a dispute, a court or an arbitration institution can do the job, typically for three reasons. Bias we've already talked about. Not having the right qualifications. There was an English case a few years ago involving someone I was at bar school with, who had to be, quote, a reinsurance expert. He'd been a barrister who practiced quite extensively in that area, and the Court of Appeal said that was okay. It's a bit borderline, but there we go. And you do get arbitrators who simply can't be arbitrators. They've died would be the obvious example. Actually, appointments die on revocation, revoked on automatically on death, but so it's perhaps a bad example. But a better example would be a disabling stroke or illness that makes it impossible to do the job. You get arbitrators that forget to do the job. The only danger of asking for them to be removed is that they all of a sudden wake up and issue an award against you. Far better in that situation for the parties to get together and say, look, it's outrageous we haven't had an award for 3 years after the conclusion of the hearing. Should we both apply together to remove this arbitrator and thereby effectively prevent him from getting paid? It's a difficult one, actually, where an arbitrator won't perform appropriately. Perhaps also they've done something which, although not showing bias, shows that they're not fit to be an arbitrator for whatever reason. The rule that you find in most legal systems and arbitration rules is that you can't challenge your own appointee unless you shouldn't have known. There's no reason for you to have known about the problem about which you're now complaining. Generally speaking, always ask an arbitrator to resign first. It's a polite way to behave. It also is required in many cases by arbitration rules. Then, if you've agreed to the institutional rules, you've got an institution that's typically happy to deal with the problem. And in a number of cases where you've agreed to a procedure, which you will have done if you've signed up for ICC or LCIA arbitration, then the national court just simply won't disagree with the result. England and the Australian model law give you a second bite at the cherry if you're not happy with the institution decision, but you have to wait till it's happened. One says this about the USA with a bit of nervousness because the Federal Arbitration Act needs a bit of updating in this space. It's possible for a court to take the view that if the parties have agreed to ICC arbitration, say that they will defer to the result of that removal process. I could certainly see that happening in the First Circuit. That's the sort of Boston area, bearing in mind their case law concerning agreements about jurisdictional disputes, inferring from the agreement to arbitrate under the ICC rules that the parties will be subject to the ICC ruling or the ICC arbitrator's ruling on a final basis, a very unorthodox view. Either way, an arbitrator is entitled to be heard. Generally, though, arbitrators should not respond to service of proceedings to remove them, except to correct factual errors. Nothing else. If you participate in an application to remove you, and you are removed, you are vulnerable to an order for costs. Generally, though, participation in an active way can demonstrate bias in favor of one of the parties, or likely against the party trying to remove you. You'd never, ever want to be accused of bias in that situation, so keep quiet, keep out of there. Resignations can be more fiddly, actually. Ideally, you agree them with the parties and sort out a way of having your fees paid. Remember, you may have to resign because of something that has come up in the dispute subsequently, which has given you a bias issue. But more likely it'll be because the dispute has become a monster you never anticipated. And in that situation, it can get very, very messy indeed. You can apply to court, in Holland and England at least, for relief in this situation and get your fees paid. But the court will look and see whether you were worthy of your fees, notwithstanding your resignation. The problem with the resignation, of course, is that the new arbitrator has to get up to speed and won't have participated. Now, there hasn't been any hearings, there won't be a problem. But if there have been hearings, then it may be necessary to get the parties to agree to the arbitrator joining halfway through the case, perhaps having studied a transcript. Otherwise, you could have an unfair hearing problem at the far end. And that's another reason why a bit of help from the court making orders in this area or from an institution could be very beneficial indeed. We talk a lot about costs in arbitration. We don't necessarily always talk about them sensibly because the area is a difficult one. Institutions are always going to charge on the basis of what's in dispute, a deposit or advance, and then the ultimate fee. In ad hoc arbitrations, you have to agree your fees with the arbitrator or arbitration tribunal, and that could produce 3 arbitrators being paid 3 different sums of money, which is not ideal. Tribunals and institutions insist on down payments, interim payments of various types, and always remember to distinguish the costs of the arbitration, arbitrators' fees, hearing rooms, facilities, food, and the like, and the parties' costs. Now, typically you carve up the arbitrators or the arbitration's costs in broadly the same way as you do the parties' costs, with the slight difference that the parties' bills have to be checked for reasonableness. So you might say, well, I'm prepared to award the claimant's costs to the claimant their costs, but actually only 3/4 of it will I order the respondent to pay. The arbitration's costs, to the extent they haven't already been collected as you've gone along in the arbitration, will be awarded in similar proportions. Many arbitrations are actually decided at the interim measures stage, and this should not be taken lightly. Nowadays, we assume, and it's in statutes and arbitration rules, that arbitrators can order 3 different types of orders. These are normally regarded as conservatory measures, keeping property or evidence. Interim measures are things that hold the balance of the dispute, stop people aggravating the problem, and security for costs, or in the extreme case where the tribunal is convinced there basically isn't a defense to the claim, they might, in the extreme situation, order security for the claim, or more likely a worldwide freezing order up to the value of the claim. When you apply for an interim measure, the tribunal should insist on a cross undertaking in damages, typically in the form of security, so that if the order should never have been made in the first place, you pay the cost of the damage you do to the other side from the order. If you're applying without notice to the other side, you're applying ex parte, you are required to give full disclosure, and the tribunal will always give a right to the other side to apply immediately to lift the order. With all interim measures, there's the option to apply to lift an order, but the inter partes ones, the ones where both parties are involved, there's usually a more sensible timetable. If you need to hit someone before they destroy property evidence or money, move money around, you may need court help. But increasingly, the courts are deferring to arbitrators. So you might wish to get an order from the arbitrator while making an appointment immediately at the end of that hearing with a judge who can turn that order into a court order. And then you can go after the respondent if they break the orders with a contempt of court application, which probably gives it a bit more bite. You'll need the court to help you if you need assistance from a third party. You want them to stop a third party, want a third party to not dispose of evidence particularly. A court's going to be needed, and you'll need some help from a court if you need straight enforcement. The New York Convention probably doesn't apply to an arbitrator's order in this space, or indeed a court order for that matter. The model law does allow court enforcement of an interim order. One note should be that a lot of modern statutes, including the model law, note that applying for an interim measure from a court does not represent a breach of the agreement to arbitrate. That's to cope with the McCreary case, where a court of appeals in the US refused to order interim measures on the basis that the court was being invited at the same time to refer the parties to arbitration under Article 2.3 of the New York Convention. Interim measures are not inconsistent at any stage with that referral to arbitration. McCreary is a silly decision, and US courts have been distinguishing it out of sight ever since it was decided. If you urgently need help, you're going to go ex parte, of course. You'll want a temporary order. Preliminary orders were introduced by the 2006 version of the model law, and a radical development they were. The idea being that you appoint an arbitrator in a hurry, you get them to make the order straight away, which is then served on the other side, typically with a request for the other side to appoint an arbitrator. Now, institutions responded to this by creating emergency arbitrator procedures. They appoint emergency tribunals, which, or typically a single arbitrator, who's not going to be hearing the actual dispute. Otherwise, you've got the same rules for interim measures, with one exception, or a couple of exceptions, the most obvious of which is that they only last 20 days, and you can't enforce them in the courts. The model law provision doesn't work. You can't deny the other side the right to apply to lift the order at any stage. So you get a degree of sort of emergency help that you would otherwise need the court help with. Again, if you have agreed to institutional arbitration, then to get the emergency arbitrator to make an order and get it converted into a judgment straight away by saying to the judge, look, this is what the arbitrator's ordered, I'd like the same order from you. And that can certainly help. Once the arbitrator has got the file, then there's a whole lot of work to do. You typically need to get everyone together to work out what you're going to be doing in a whole range of areas. In the ICC world, alone, the ICC seems to insist on terms of reference. That provides a degree of focus for everyone. But you may have any interim measures that need sorting out, and even an emergency application for security for costs or the claim. The terms of reference, well, this is what it consists of. And a well-organized arbitrator could probably do this off the request for arbitration and answer and counterclaim and replies, etc. But often it helps to suggest to the parties that they fill in the terms of reference or comment on the draft. It needs to be signed by the parties, although if a party objects, that's not a bar to sending the terms of reference. It has to be sent to the ICC. If you object to jurisdiction, the smart thing to do is to consent, but insist that the terms of reference note your jurisdictional objection as one of the issues to be determined. That's not a problem. The Court of Arbitration, not the Secretariat. Secretariat is the bit, does the day-to-day management of the ICC. The Court of Arbitration approves the terms of reference, and that kicks off the next part of the case. Gabriel Kaufmann-Kohler, one of the most important arbitrators in the Swiss world. The arbitrator, whether it's ad hoc or ICC, has an urgent job to sort out what's really in dispute. The terms of reference won't necessarily answer that. They also have to work out what sort of proceedings we're going to have. These are all going to be documents. Do we need to consolidate here arbitrations or hold them concurrently or anything like that? We know from our work on consolidation that you won't get this happening without party consent, and institutions won't push people into it. There's a possibility the Swiss rules they allow the Swiss rules institution to actually force a joinder having considered the parties' views, but be very unlikely to do that in the absence of party agreement. And then you've got to set the timetable and any urgent measures that are needed. There may be urgent discovery required. So what's on the timetable? Discovery always is a problem. When are we going to present the case in more detail? Are there any preliminary or other hearings required? How many witnesses? How are we going to exchange their witness statements? And when are we going to have a pre-hearing review? Look, these timetables issues come up as the case progresses. They won't all come up at the start. And finally, are we happy with closing submissions and how long after a final hearing? This is Cedric Barclay, one of the great maritime arbitrators, and a great writer about the subject as well. Arbitrators can always appoint experts, more commonly done in civil law countries, in my experience, although they can be appointed under the Arbitration Act 1996, as they could under its predecessors. In fact, Lord Mansfield in the 18th century, a famous commercial judge, frequently used to appoint assessors to sit with him to advise him on maritime matters. Typically, though, this is an all-lawyer tribunal being required to decide a highly technical point for which they really don't have the necessary expertise. The trouble is it creates a sort of bifurcated procedure where the parties are trying to persuade both the tribunal and the expert. Technically speaking, it's for the tribunal to be advised by their own party-appointed expert. Sorry, by their own tribunal-appointed expert. We'll talk about party-appointed in a split second. The tribunal is never bound by a tribunal-appointed expert's view. They're very influential, obviously, when they're appointed, because they're appointed to fill a technical gap that the tribunal has. Often the parties will themselves have their own experts, and it may appear that there's actually a parallel case going on with the two expert witnesses not being witnesses in the traditional sense, but making submissions to the tribunal-appointed expert. Anyway, the tribunal can arrange a site expert. It can agree on the evidence that's going to be looked at, what legal matters, get the bundle sorted out, how we're going to make submissions, and what sort of witnesses, who are going to be available, what sort of cross-examination are we going to have, the old common law style, examination, re-examination, examination, cross-examination, and re-examination, give the right order. Increasingly, a form of mixed common law civil law is emerging, in which there is a sort of form of cross-examination, but much more tribunal involvement, particularly to assist parties who are less competent at cross-examination. One thing everyone seems to be agreed about is that the rules of evidence don't apply. There's the rules of evidence, the seat of arbitration, because they apply to court proceedings, not arbitration. there's something in the Arbitration Act, well, that would apply. It typically isn't. There are a number of different ways you can organize pleadings. Go for limited pleadings and then a big pre-hearing submission, or even a presentation at the start of a hearing, although those are increasingly out of fashion. You can also have the full works in one document. I'll show you how this works. This is Yves Fortier, Canadian arbitrator. If you fit those things together, you'll end up in roughly the right place. The plan really is to get all the documentary evidence in the right places, although there can obviously be cross-references to bundles of agreed documents, which makes much more sense in a very, very seriously documented case. But the difference here between this and the skeleton form of presentation of the case is that you plead the facts and evidence and the law. Typically in a skeletal version, you only plead the facts. So you can see, you want to know what the value of the claim is, and you want to know what the remedy is, but you don't put in the evidence, you don't put in the law. What's important is that the parties understand what's expected of them. On this subject, discovery is an absolute nightmare, because traditionally we have the Americans up one end with more discovery than anyone else, the English in the middle and the other common law countries, and then the civil law countries with more limited discovery. It's ultimately the arbitrator's job to delimit exactly what they want to be disclosed. Are you going to do it by using lists? Are there going to be inspections? Are we going to have an e-discovery protocol followed that will help us get into each other's computer systems? What copies will be supplied? Be aware, though, of problems with privilege, both legal privilege and the privilege against self-incrimination. The former in particular, the rules are different in almost every country, and there's always an argument, oh, I can't disclose that, or it's the possibility of an argument, I should say, doesn't come up that often in practice, of a legal professional privilege or litigation privilege, and a slightly different argument coming up. If a party is going to rely on that, they really do need a proper independent legal opinion. And a certain amount of nervousness is not unsurprising on the part of tribunals. The effects of not complying with orders is a bit messy. Often people use unless orders, unless you comply in the next 14 days, I'm going to issue a peremptory order. That's going to stop you relying on part of your case, which is typically the bit that's affected by the discovery breach. Or, well, I'll just draw inferences against you. At the most extreme end, you could end up dismissing a claim or a defense, typically again following an unless order. But always remember the key total absolute rule. You cannot waive the right to a fair hearing, but the tribunal is also required to adopt procedures to avoid unnecessary delay or expense. That's written into the ICC rules. And frankly, it should be written into everybody's rules. Increasingly, arbitration rules are giving arbitrators the power to limit the amount of costs that can be spent on a case. And such orders do at least have a disciplining effect, because if you exceed the spending limits, you're not going to get them recover your costs, even if you win the case. Parties can always agree not to have such limits, by the way. In the hearing, if there is one, there are certain basic rules. We don't let outsiders in without everyone's permission. We Don't limit who can represent whom. Don't have to remember the local bar. Singapore many years ago had a rule like that and lost a lot of arbitration business as a result, and rather rapidly changed its rule back again. Make sure that everybody knows where, when, and how the hearing is going to happen, or any hearings. And remember that one side might just say, well, I'm not turning up. You still hold the hearing, you still keep a transcript, you still require typically the claimant to prove their case properly. And you must keep a record, be it a tape recording or a stenograph or something. And finally, remember that everybody needs to be able to find some food and drink. Maybe they can just nip out and purchase it themselves, or there may be facilities laid on. That's part of the costs of the arbitration typically. There's no strict rules about the order in which you hold an oral hearing. This is a standard way of doing things. You do the same with the experts. Never swear a witness in, it's pointless. It's also banned by a number of countries. You typically just invite a witness to confirm the accuracy of their statement with any amendments that's applied to both sides, the other side, because in the tribunal, because typically you do get slips in witness statements. And then the other side to the witness cross-examines. If the tribunal is aware there could be a problem with that cross-examination, they should be ready to provide cross-examination themselves of every witness in a fair way. If your witness has been cross-examined, you in theory are entitled to examine them again to clarify any points that are, where typically the witness hasn't quite said what you expected them to say. Don't use this unless something has gone badly wrong, because you will be indicating that your witness has not come up to proof. You get very little benefit from re-examination in practice. Now, there is a problem in that tribunals have to make it fair for each side, give each side a fair chance. And some people will ask more questions than others. And various techniques have been used to sort this problem out, chess clocks. The trouble with a chess clock is if one side is trying to burn their allocation of time and the other side doesn't use their allocation at all, then you could end up with a witness not being cross-examined or something like that happening, which wouldn't be very acceptable. It's very, very difficult to get this right. Particularly if the party who used a lot of time actually knows what they're doing when cross-examining. There is an English case which says that any order is okay as long as you give each side a fair chance. That must be right. So we've seen that you could get rid of evidence in chief. They're the countries where you're not allowed to swear a witness in, but pointless anyway. There are limitations on the arbitrator's powers. That, by the way, is John Roberts, the Chief Justice of the US Supreme Court, and also an arbitration practitioner. You can't get non-party witnesses to turn up, and that's a problem for which you may need a court order. And the provision is made under Section 7 of the Federal Arbitration Act. You can't go beyond the issues referred to in the arbitration. And as Fox and Welfare, an old English case, points out, if you have your own view of the case, you have to disclose it to the parties and invite them to make submissions on your view if it doesn't have to be one of the parties' views. Question mark as to whether that extends to points of law. In the civil law tradition, the arbitrator is the master of the law and can find its own law, if you like. I still think it'd be very unwise in an arbitration not to tell the parties which legal rules you're thinking of applying that neither side has already thought about. We know that you can't award more than anyone's claimed. You can nudge a party a little bit into perhaps amending their claim, but there's a danger if you nudge them too hard but you will be showing bias. And above all else, you're pinned in by the parties' agreement. The parties agree to have an entirely pointless hearing. You have the entirely pointless hearing, whether you like it or not. Some matters you don't touch. You can't lock someone up, obviously, for perjury. You've no business dealing with that stuff. We now need to look at the applicable law. We've already learned that lots of different applicable laws may be in play in the single arbitration. Courtesy of Enker and Chubb, we know that the parties can agree to an applicable law governing the arbitration agreement, may be different from the seat, and a court may infer from an express choice of law to govern the contract as a whole that the law selected will govern the agreement to arbitrate. The reference to arbitration and the procedure may be the same thing. The reason why we talk about different rules here is because of the cases involving the abandonment of an arbitration, typically by one party forgetting to pursue it for many years on end. They don't abandon the arbitration agreement, they abandon the reference, which is different. It's governed, therefore, technically by a different law, particularly if the parties have agreed to have this the seat of arbitration for a particular reference, one country, even though the arbitration agreement has no governing law. And then, of course, the substance can be governed by a different law altogether, notably if the parties have agreed to that. Generally speaking, modern arbitration, the view is that the arbitrator does not have a lex fori. In other words, does not, because it is not a judge, not have to apply the private international law or choice of law rules of the seat of arbitration, or any other country for that matter. And that in itself creates its own problems. One last thing you should consider is whether you've got a false conflict. There are plenty of cases where there's been great effort gone into by parties and arbitrators to decide which law is applicable, only for everybody to discover that the rules are identical between two of the contending applicable laws. This is pretty pointless, and false conflict should be avoided at all costs. If you've got two parties contending for different legal systems that produce the same result, as a tribunal, usually best if you can to say, look, it just produces the same result, so I'm not going to decide the point. That's not possible if it comes up as a preliminary matter at a time when you don't know what rules will be applicable to the actual dispute because you haven't heard the evidence properly. So you may end up with a false conflict whether you like it or not. But that's what they are, and try not to make decisions on applicable law points that don't actually come up for decision. In general, if we look at the seat of arbitration, we say, well, their law applies. Their arbitration law does anyway. We saw that in Swiss law and Dutch law, there are provisions for holding arbitration agreements to be valid if they are valid under a number of other laws, notably that governing the merits. That's a statutory provision. You could always contract out of these provisions, usually, almost invariably you can anyway. It's an interesting question about the Swiss statute and the Dutch one on substantive validity. Otherwise, even Enker and Chubb owns up to the fact that in the absence of a choice, the law most closely governed to an arbitration, closely connected to an arbitration, is in fact that of the seat of arbitration. But if there is no seat of arbitration, then there's an obvious risk following Enker and Chubb, and indeed case law in other parts of the world. The court will apply the law governing the substance of the contract, treating the whole thing as one and the same. Let's though concentrate now on choice of the law to govern the substance of the dispute. I said it with slight nervousness because choices of law may govern the contract. This law contract shall be governed by, or the parties may agree for an extra contractual dispute to be governed by a particular legal system. Either way, you could be choosing a municipal law. Don't do public international law. It's not designed for this purpose. And you end up applying the rules common to civilized countries or something silly like that, which doesn't produce good results. You could agree to a non-legal standard, but it'd be wiser to only do that where there is a huge case law in the particular sector as to what that means. If you're doing a retail financial services dispute in England, there are books worth, I know because I wrote one of them, on what clear, fair, and not misleading means and what fair and reasonableness means. Inside the non-reasonableness, sorry, in the fair and reasonable standard, we find a number of variations. Berthold Goldman was once famously asked what the word amiable added to the notion of amiable composition, and like a good Frenchman, which he ultimately had become, he said atmosphere and left it there, which is probably about the right answer. But these are all the same thing. You could agree to refer your matter to the rules of a particular religion, particularly if you've got a religious tribunal, which helps. Be aware, however, that within different religions, there are particular schools. And if you don't indicate clearly which school you mean, you could end up with some pretty random results. Although, frankly, if you refer your dispute to, say, the London Bet Din, which is fundamentally an Ashkenazi Jewish Orthodox body, that's what you're going to get by way of applicable version of the Jewish religion. And then the awkward one is the lex mercatoria, which a lot of courts accept to be, in fact, a legal standard, although honestly, I'm not sure it is. Let's say a few words about non-legals. So these three are really the same thing. And they have to be expressly chosen. That's the consensus position in the model law and virtually every other legal system. There is in some legal systems an assumption that law is actually fair, and therefore, if you're going to part from it, you really ought to explain why. We find that in the English case law, not on arbitration, but in the parallel area of the Financial Ombudsman Service. I'm not sure you should have to do that. Now, the parties may have chosen a law, but it may not be applicable for a number of reasons. The most obvious of which is that the effect of applying the chosen law is offensive. Now, it may be offensive generally, but it could also be offensive to the law of the seat of arbitration, which ultimately is the focal point for the arbitrator, since the first challenge to the arbitration award is typically a setting aside application. In the Audi NSU case, that involved an enforcement problem, I think, and so the New York Convention case. And when a party select a seat of arbitration, an applicable law in a country entirely in order to dodge the application of an otherwise applicable statute, then the country of that statute is never going to be a happy place if you end up in a courtroom. There is also the problem of mandatory laws. These are typically competition law problems. There's the Austrian Supreme Court case where they refused to stop the court proceedings when the arbitrator in the US announces that he will apply New York law to the antitrust dispute, not the law of the European Union. If the facts of the case mandate the application of the law of the European Union, you can see why a national court will do that, why an arbitrator might want to be a little bit careful on this subject. Perhaps consider claims under all the different possible legal systems. Because a mandatory law is a time and space thing, it isn't to do with the parties' agreement. And typically it's a tort claim, not a contract claim. You know, this contract shall be governed by doesn't cover as the US Supreme Court suggested in Mitsubishi footnote 19, the antitrust claim, which concerned the transshipment of cars from Puerto Rico to mainland Florida, obviously is happening in the United States of America with impact on that market. The fact the parties have chosen Swiss law to govern the contract and the seat of arbitration in Japan should, in the eye of the US Supreme Court, not make a difference to that view. Now, the case never was arbitrated because Solar went bankrupt, so we'll never ever know. At the time when that decision was made, everyone thought this was rather eccentric of the US Supreme Court to express the view it did. As time goes by, and there's more and more discussion about loi de police, I'm not so sure. I'm starting to change my mind. Certainly, if there'd been enforcement proceedings in the US and the arbitrator had not considered the treble damages claim, I think there could have been a problem. But it probably wouldn't have come up that way because because typically the claim, of course, was being made by Solar against Mitsubishi, and Solar wouldn't have been applying to enforce such an award that had not taken into account. It would have been Mitsubishi seeking to rely on the award as a defense against a subsequent claim from Solar. That would have been the scenario in which the problem might have arisen. Another problem is maybe the choice of law only covers the contract. The contract is governed by such and such a law, but we've just made a tort claim or an unfair competition law claim or something like that, which isn't simply not covered by the choice of law. There's three reasons, often interconnected, why a choice of law might not be observed. We can give you a real live case which was reported. This involved Monte Carlo Hotel with Monte Carlo rent control laws. The parties aware that there could be a limit placed on the rent, which was rather lower than they'd actually agreed, entered into a separate indemnity agreement governed by German law and with a seat of arbitration in France. And the idea was that in the event of rent control being applied, indemnities could be awarded by the arbitration tribunal in the event of a dispute in this French arbitration. The question then came up, what was the applicable law? Well, the answer was German. Okay, but what about the intentional evasion of Monte Carlo law? The tribunal sitting in France are thinking, well, hang on a second, this can't be a problem because France has no interest in the enforcement of a rent control law between two very significant sized businesses over commercial property in Monte Carlo. Only if the arbitrator had been sitting in Monte Carlo and Monaco would Monte Carlo or Monaco public policy have been applicable. And that's ultimately how the case emerged. So the claim for under the indemnity agreement is upheld. Now you could argue, and it was argued, that the hotels were located in Monaco and therefore Monaco law should be applicable. But the reality was that the seat of arbitration led the tribunal, if you like, to disregard this law. And anyway, they said, well, we're not saying that the rent control judgment is somehow invalid. We're just saying that the parties can agree in a private contract, which is completely inoffensive, to undermine the effects. Where the parties have not agreed on any applicable law, things become inevitably more complicated. We've already pointed out the need not to apply the conflicts rules of the seat of arbitration, although in some cases it would make a lot of sense if arbitrators did, particularly when they're well documented, well set out. I'm thinking here of Switzerland, where the LDIP, which in our arbitration context we think of as an arbitration act, contains detailed provisions on applicable law, but would be quite helpful to an arbitrator sitting in Switzerland. But the consensus is that it's not the right way to go about it. This is the standard rule nowadays. Typically, the rules of law most appropriate or closely connected are the ones that we are supposed to apply. It's not very clear whether there's any difference between most appropriate or closely connected. And again, there's some dispute on the reading of the Swiss LDIP Article 187 as to whether it's the law most appropriate or most closely connected to the issue or the dispute as a whole. But most arbitrators navigate their way around that problem. It doesn't come up too often. Anyway, this approach of going straight for or using the arbitration statute, if you like, or as a conflict of law rule is in fact a voie directe. Now, you do get situations where the parties have agreed to ICC or LCIA or Swiss rules arbitration, and those rules have their own choice of law provision, typically the one we've just looked at. So even if your seat of arbitration is an UNSTRAL model law country or England, you've probably agreed to this form of voie directe, because the most appropriate conflict of law rules would be those rules laid down by the institution to which the parties have already agreed. Otherwise, we're looking at a voie indirect. But the problem with voie indirect, what is an appropriate conflict of law rule? Is it the conflict of law rule most closely connected to the dispute or issue? That does produce, frankly, nonsense. What you can end up with is a comparative law fest in which everybody throws in the conflict of law rules adopted by the legal systems of all the countries that could possibly be connected, and one or two that are just interesting, which doesn't make an enormous amount of sense. This sort of search for agreed private international law is sometimes a little silly. An interesting example of this phenomenon, which was actually brought about by the arbitration agreement, was the Rainbow Warrior. The story is well known. These are the connecting factors. The agreement negotiated by Pérez de Cuéllar, the Secretary General at the time of the United Nations, between France, New Zealand, and Greenpeace, was that disputes would be resolved applying a municipal legal system, but not using the seat's private international law, which was a little bit silly. Switzerland was the seat of arbitration, and ultimately the tribunal ended up with English law, which was, I suppose, the law where the loss was suffered most, being the headquarters of Greenpeace. It probably should have been New Zealand, which was where it all went wrong. But actually, of course, there's a false conflict here, because New Zealand and England have almost identical, if not identical, laws relating to the measurement of damages, which was the only item in dispute. The Lex Mercatoria, well, invented by Berthold Goldman, a fine man, but I'm not sure it's done the world a great deal of good. Clive Schmidhoff could also claim to be something of a joint founder. Yes, if parties have expressly chosen to have it, that's fine. Quite a number of countries who use the rule of law formulation in their arbitration statutes are impliedly allowing it as well. What is it, though? Is it a law? Not really. Lord Mustill wrote a fine essay in the Festschrift for Lord Wilberforce, which goes through what he could identify as the rules of the Lex Mercatoria at the time, but many of them were rules which also had countervailing limits. You know, we're in favor of contracts being enforced, perhaps not 20 years later when the circumstances have radically changed the nature of the bargain. Berthold Goldman relied very heavily on the ICC rules provision, which says that in all events, the tribunal shall rely or apply the rely on or apply the usages of the trade, he suggested that things like standard form agreements, like Incoterms, the ICC provisions on letters of credit should apply. But really, if you haven't agreed to Incoterms applying to your letters of credit, why should a tribunal apply them for you? It's a very, very uncomfortable area in which there's a sneaking suspicion that the lex mercatoria is neither lex mercatoria or mercatorial. It's not mercatorial, it's not the law of the business world, it's actually the law of the law professor. And that's a problem in itself. Is it really just a right-wing view of commerce? I don't know. Normally in English law, we require custom to be proved. In general, when the arbitrators get it wrong on the applicable law, there isn't an awful lot of control by the courts. In English law, if you haven't agreed to exclude the right of appeal on the question of English law, by the way, not anybody else's, there can be an appeal with the leave of the court. We'll talk about that at a later date. You will have excluded your right of appeal if you agree to institutional arbitration, ICC, LCIA, Swiss rules. They all remove the right of appeal in effect. In the US, there was a long tradition of manifest disregard of the law until the Hall Street case, which suggested it probably should be regarded as having expired, with Wilco and Swan, the judgment in whose detailed wordings you will find traces of manifest disregard of the law. But Stolt-Nielsen revived it when the Supreme Court indicated that reaching a result without paying proper regard to the terms of the agreement or the applicable law constitute an excess of jurisdiction. That's a view almost never held anywhere else. One possibility has always been, in the Dutch and French and Belgian statutes, the ground for setting aside awards but not conforming to the arbitrator's mission could be regarded as picking up a refusal to apply an applicable law. But the English approach in ICC cases or other cases where there's been an exclusion agreement is that if you start the case with jurisdiction and they don't award a remedy that's been excluded by the parties, you cannot exceed jurisdiction. In that respect, the English House of Lords, that then was now Supreme Court, disagrees profoundly with the US in Stolt-Nielsen. And in Switzerland, there isn't any control over choice of law at all. The only possibility is that one could rely on statements in the Swiss Supreme Court that pacta sunt servanda is a principle of Swiss public policy. And I think that's probably stretching it a bit too far. You can have public policy review getting in the way here in choice of law because on the one hand, we've seen that pacta sunt servanda could be a form of public policy. On the other hand, a mandatory law might require the chosen law to be disregarded. And it depends a lot on where the case turns up on a setting aside application or an attempt to enforce the award. Generally speaking, courts don't like messing with the merits of cases. However, there is an English case or two in which the courts have refused to enforce treble damages awards coming out of the US on the basis that their version, the US version of punitive damages, bears no relationship to the loss suffered, whereas the English version does. Slightly specious view. What they did then was to knock off 2/3 of the damages award, declined to enforce that. In general, though, on enforcement, courts are interested in what the result of the choice of law was, not how it was reached. And that does reduce the number of awards that are denied enforcement in this space. in reality, if you misapply, your voie direct or voie indirect, there is absolutely no control over the outcome, over the arbitrator's award. So, this is why we have to discuss this by reference to statutes and arbitration rules rather than cases, because there are so few cases. And that takes us to the arbitration award itself. And that's Lord Collins, distinguished arbitrator and ultimately judge of the English Supreme Court. One point we will make before leaving is that an arbitrator can issue partial awards and it can issue rulings, and there's a difference between the two. A ruling you can always reverse, a partial award you can't. An award needs approval from any institution, a ruling probably doesn't. You might use a partial award to pick up different bits of the case in a more digestible form. There's always obviously a danger if you use a partial award, that you issue a distinguished award, finding one party liable, and then finding that actually in the second hearing that there has been no loss suffered. And all too often, perhaps, there is no separate award on costs. It's rolled into the final award, which effectively denies the parties the opportunity to make a proper submission on costs based on a knowledge of how the arbitration award is going to come out. And that's not very desirable either. One solution, I suppose, would be to show the parties the draft award on liability and damages before it's formally issued, on the basis that it will not be changed, however. But that would break the rule of the secret du délibéré, the secret of the decision-making process, and wouldn't be acceptable. In reality, what happens is the parties submit their bills, make any points they have to make about the other side's bills, and any wastage of costs during the process, and then leave it up to the tribunal to make the decision. Rulings can be reversed, which is one reason why they're quite handy, because you have to be very, very careful ultimately never to issue a final award without having covered something. Once you've done that, you become functus officio. You lose your power as an arbitrator unless the parties give it back to you when they point out to you, perhaps a court points out to you, you haven't finished the job off properly. Just be careful, please. And that, I think, takes us to the end of class 9. I hope you found this helpful. It's been difficult to summarize in one go, but there we have it. I look forward to seeing you at class 10.